Hey everybody, I'm Juanita. I'm from Cape Fear Family Law. I want to go over a case with you today for our case update for our state, North Carolina. The case that I'm reviewing with you is Walsh v. Jones. Forgive me if I look down a little bit. I have the case sitting over here beside me just to help me get through it. So this case was filed on January 15th, 2019. So it's a very recent case. It's with the Court of Appeals. It comes out of Duplin County, North Carolina, with the trial court judge being Judge Carol Jones. The case facts are very important in this case, but let me jump ahead a little bit and just tell you what we're going to get out of it at the end of the day. So this case is focusing a lot on modification of child custody. And what do we as attorneys have to prove for you to have a successful case on modifying child custody? This case was an extreme example. This was a case where a father lost all rights to his child. All visitation was suspended due to some drug use. But let me back up and give you some facts on it. So a few points I think you're going to find out of this case to be most important are: number one, how much weight does the court give the child's wishes in a modification case? Number two, what are the standards of proof for a modification? So child was born in 2004. In 2005, mom leaves dad due to some domestic violence. Father has some drug addiction, some anger issues, and so mom is awarded emergency temporary custody. She then files for custody, and she is given custody. Fast forward several years, several hearings where the modification goes back and forth. Dad's clean, dad has a relapse, dad's clean, dad has a relapse. When finally mom files for emergency custody because father has some pending felonies for his drug addictions. Father then serves 5 years in prison and in 2015 is released. In 2016, father files an action seeking to begin his visitation again, seeking to modify that court order so he has some rights to his child and so he can see her. And the court finds that while the father was in custody, the father successfully proves in his motion that he attended DART, which you may know is a drug rehabilitation treatment plan that's offered through the jails. He attends Narcotics Anonymous. He attends Alcoholics Anonymous. Father goes to some church services, participates in community service. Father pays child support. He's receiving disability payments, so he pays his child support out of those disability payments. The court finds that dad had some genuine love for his daughter and that he has some stability in home. He's living at home with his mom, who's a registered nurse. So he has a stable home environment. He has stable income through his disability. He's going to continue paying his child support. So they find that dad has made some significant changes. So the court rules, in this case, the court specifically rules that they award the modification. Judge Jones, she said that he had met his burden and that he had in fact had a substantial change in circumstance. So that's number one in the elements that we look for in a modification case. Do we have a substantial change in circumstance? The court goes on to say that substantial change has to have an impact on the welfare of the minor child. And they go on even further to say that impact on the welfare of the minor child can either be adverse, meaning it could harm the child, in which a modification is necessary, or it could benefit the child, in which case a modification is necessary in favor of the father. Interestingly, the court then went on to say that the minor child herself had some input in this and testified in chambers. We don't know what the child testified to. There is some allegation in the Court of Appeals report where it says that that mom says the child didn't want to be with dad. And the court seems to dismiss that altogether and says it doesn't matter to us really what the child says. It matters to us what we believe is in the best interest of the child. One of those was reunification therapy with Dr. Jerry Sloan, who was involved in this case from the outset, and to continue on with that therapy with the child, to help the child to feel better about that reunification. So the court parents ask us, can my child testify? Can my child testify? And some consideration needs to be given to that. But we also have to recognize that the court doesn't have to put a whole lot of weight into that child's testimony. Hey, we know that this child may have a difficult time reunifying with dad. That in and of itself does not say we shouldn't do it. We're going to anticipate that issue and we're going to give you some solutions. So this court tried very, very hard to give these parents the steps and the avenues to make this easier on the child. Please note, we're not trying to make this easy on the parents. And I think the court did a very good job of saying, we know and we recognize that this child may have a hard time. That's just not enough for us to deny her access to her father. Okay guys, so we're gonna have some ongoing case reviews and some interesting facts coming out of these cases. So subscribe, leave it down, just hit like, make any comments. I can reply to any questions you may have. I look forward to seeing you guys. Thanks so much for watching.